Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. It's kind of one of these rare videos where I'm going to get it a little bit more in depth than I usually do regarding jurisprudence, sort of American constitutional law, sort of comparative law, and we're going to kind of touch on, although it's from the title of this video, it probably seems like this is going to be more about politics than it actually will be, because what we're actually talking about here is the doctrine, the political question doctrine, which exists in American jurisprudence, specifically the American legal analysis regarding U.S. constitutional law. This can be especially, and you could also look at this from a civil procedural issue with respect to the notion of standing in the U.S. court system, and just kind of comparing this, contrasting, just kind of looking at the overall system. So to give some background here, I'm going to go to constitution.finelaw.com under the heading, The Supreme Court and Political Questions. Quoting directly, what is the political question doctrine? And then this is from the source, United States Library of Congress, Constitution of the United States of America, Analysis and Interpretation. Quoting directly, the political question doctrine limits the ability of the federal courts to hear constitutional questions even where other justiciability requirements such as standing, ripeness, and mootness would otherwise be met. So when we're talking about standing, we're talking about, are you somebody who's actually been harmed and therefore you have standing in a case? Is the case ripe? Has a law come into effect that now impacts you? Is the case moot? Has a law ceased to exist, which no longer affects you, so you don't have standing? These are issues that have to do with standing to be heard in a court. Now, even where you may have standing, it may not be a moot issue, it may be a ripe issue, you may still have a problem in certain American courts with the issue of this political question doctrine. So quoting further, the Supreme Court has stated that for purposes of Article 3 of the Constitution, quote, no judiciable controversy exists when parties seek adjudication of a political question, end quote. Quoting further from this excerpt, but the term political question is a legal term of art that on its face gives little indication of what sorts of cases the doctrine bars federal courts from deciding. The phrase, which has its origins in Chief Justice Marshall's landmark opinion in Marbury versus Madison, is potentially misleading, as federal courts deal with political issues in the sense of controversial and government-related issues all the time. Rather than referring generally to any such political issue, the term, quote, political question, unquote, expresses the principle that some issues are either entrusted solely to another branch of government or are beyond the competence of the judiciary to review. Quoting further, finding that a matter qualifies as a political question divests federal courts of jurisdiction, meaning they lack the power to rule on the matter. The reason I bring this up is we're seeing a lot of political stuff going on, not only in the U.S. I'm not saying that I think that there should be sort of a parallel doctrine under Thai law by any stretch, but we are seeing more and more in the past roughly 40 years, I'd say, in the United States, and quite honestly, it seems to be more acute in Thailand, where this trend has been kind of moving forward, in the past 20, 25 years here in Thailand. The issue of political questions and the sort of, especially in the U.S. Supreme Court context, the more activist courts, it just seems as though the court, and I'm talking about the U.S. specifically here, has been more politicized than ever. They're dealing with more political, I won't say political questions, because if it is a political question, it is therefore not something they're going to deal with. But as they note in that excerpt, they deal with political issues all the time, things that have political ramifications. The question becomes, in my mind, at what point is it maybe a good idea for the court to just simply kind of throw up its hands and say, hey, this is a political question. Courts are law courts. Courts are not political courts. They're not there to be political actors. They're there to adjudicate cases at law. Now, that can get kind of complex when you're dealing with constitutional issues, for example, or issues that may be it may be an actual case or controversy that's really not in and of itself political, but it has fundamental political ramifications. Now, where you draw the line between saying, look, a case may have political ramifications as opposed to, hey, this is a political question, we're not going to get into that. I guess that's an issue for the judiciary to deal with on their own. But I do think it's worth noting that a lot of people sort of in the general public, in many places, I think, this could be said in the United States most assuredly, maybe even could be said here in Thailand, but even around the world, I think there's been a lot more pressure placed on courts generally to adjudicate what in the past were clearly defined as political questions, and courts would just kind of say, look, that's not our role. We deal with opinions, findings of fact, conclusions of law. We're not here to act as sort of political referees. Now, whether or not this trend continues, it remains to be seen. It's interesting. I'm not really bringing this up to discuss anything specifically. It's just, I do think that people have kind of conceptually forgotten that at some point, especially in the American jurisprudence tradition, there was a point in time where the judiciary said, hey, look, it is not our function to act as arbiters of political questions. We're simply here as judges in courts of law in order to adjudicate cases at law. And I think that's definitely something the general public has forgotten.